Okay. Well, hello there. I have it. It's about 12:01. We're going to go ahead and kick things off. First off, welcome to today's Government Platform Accelerator webinar. This is an ongoing series where we highlight important topics for our portfolio firms to help prepare you and help arm you to build and grow your government business. My name is Barry LeFew. I lead our Government Platform Accelerator. We have a terrific topic today to talk about, and that's really around the importance of government contracting and getting things right from a legal perspective. And while doing this the right way can result in enormous opportunities for firms. Not doing it the proper way, right, can potentially put you at risk in terms of future revenue, intellectual property, and all other types of important things. So it's a very, very important topic to cover. Um, as we usually mentioned, this is really provided as an educational format for our portfolio firms and for the In-Q-Tel partners. The no government funding was used for this program today. And again, this is meant to be educational. Before you make final decisions, you should consult with appropriate experts and legal staff in your organization. So with that, I'd like to talk about our speaker today. We really have joining us a great speaker with a ton of expertise, and that's Ashley Powers. Ashley is counsel at Miller and Chevalier, which is a prominent DC law firm. Ashley, in prior experiences, has worked in the government, including several years at the CIA, and she really specializes in government contracting and has extensive experience with topics such as data rights, litigation, and really important things, best practices for putting in place effective government contracts. And as I mentioned, she spent several years working at the CIA, where she helped focus on emerging technologies and important new solutions for the agency. So with that, we'd like to welcome Ashley. Ashley, be welcome. Be great if you tell us a little bit more about your background, and then we'll kind of start jumping in with some interactive questions and answers. And I did want to remind everyone, Ashley, that this meeting is being recorded. If you have questions, you can use the chat feature to send us your questions through Teams. We will have a Q&A at the end where we will review your questions, but as we're going through it, feel free to pop those questions in and put them in the chat feature. So Ashley, welcome. Tell us a little bit about yourself and your background.
Sure. Thanks, Barry. Really happy to be here and a pleasure to sort of meet all of you out there in the Teams world. So again, my name is Ashley Powers. I'm a counsel at Miller and Chevalier in DC. As Barry was saying, I spent 6 years at the agency where I worked in the contract law division and the Office of General Counsel. For quite a bit of that time, I was focused on the agency's efforts to bring in new and emerging technology, so have a lot of insight into how the agency views the importance of bringing in companies like that, but also some of the issues that can arise, particularly in the tech space with IP and data rights, but then also just the compliance hiccups and issues that can arise when you're a new entrant into government contracting, particularly within the intelligence community. Before that, I was with another law firm in Chicago, Morgan & Lewis, where I split my time between government contracting and sort of more traditional commercial litigation. But I got my start in government contracting at the Department of Commerce. I worked a lot with the National Oceanic and Atmospheric Administration and the National Institute for Standards and Technology. So all in all, I've been practicing government contracts for about 15 years. I came over to Miller and Chevalier about 1.5 years ago, really with the express desire to help new and emerging technology companies navigate building their public sector business, specifically focused in the defense and the intelligence community space. So I've been focused a lot on doing that for the past year and a half, and again, focusing on compliance obligations, data rights, intellectual property issues, and all of the issues that are just a little bit more unique to those particular government customers.
Great. Thanks, Ashley. That's a terrific background and experience that you're bringing to today's event. So, Ashley, the title of our webinar today was, Beyond GPT, right? And AI is all the rage. It's being used for all types of use cases. But Ashley, let's talk a little bit about, why not, why you shouldn't use generative AI for legal types of use cases and expertise. And it'd be great to kind of get your perspective on that, and maybe share kind of some situations that have happened out in the real world today.
Sure. And so just for some people are visual learners, some are audio learners. So I have a couple of slides, just very high level, to help us along with this conversation. So if you just bear with me for a minute, I'm going to share those. Everyone can see that? Okay.
Yep, it looks good. I can see your slides.
Great. So the first issue that I think generative AI has a lot of promise, and I think in a couple of years, maybe even, it will be more useful and can probably start to meaningfully replace some of the functions that lawyers currently serve. I hesitate to say that we're currently there. And some of those issues are solvable, and I think some of those issues are not. So one of the first issues is that there's not attorney-client privilege in any of those communications. And that can sometimes seem like a remote or sort of abstract concept when you're negotiating a contract. But when you think, as you sometimes have to think about, if this is ever going to end up in a dispute, some sort of contract litigation, that's generally stemming from disagreement about terms in a contract. And if you've engaged with AI to draft those terms or modify those terms, those communications could be discoverable in that litigation. In other words, they wouldn't be privileged. And that could really impact the strength of your case. One of the other issues is that the documents and the information in them is essentially now public. And so to the extent there's any confidential or proprietary information in those documents, that can be harmful from a financial perspective if you're disclosing your company's own confidential or proprietary information, but also if you've executed a non-disclosure agreement or anything like that, you might be in violation of that agreement. And so those are two issues that I think are sort of always going to be a little bit of a problem, but the lack of nuance and the unreliable issue spotting, I think that's something that maybe could get ironed out eventually. But there, what I'm thinking of is for more complex issues like intellectual property or data rights, when you're going to really have to get into the weeds of the particular technology you're dealing with and or the technical data you're talking about, AI can maybe give you a really high level answer of, okay, well, if you've developed this with private funding, you should be able to assert limited or restricted rights, versus if you're using government funding or even mixed funding, the government is probably going to be entitled to more rights. But when you're starting to get into, okay, but what rights attach to which piece of technology that you have, and how do those all interplay together, I don't personally think that AI is able to give that level of granularity to clients. They're also not going to necessarily understand what issues are particularly important to you and your business, or what are outside the realm of normal. So for example, a lot of subcontracts will have warranty provisions, and that's not generally something that I spend a lot of time getting hung up on, or that clients get hung up on. But I was recently reviewing a subcontract for a client who operates in the defense space and is a non-traditional defense contractor. And there was a warranty provision that was quite excessive, and it was frankly excessive to the point of covering the useful life of the product that our client was going to be delivering. And so it could have been read to essentially require our client to replace the product every couple of years in perpetuity under the guise of the warranty provision. And so that was something that we flagged for the client that was really meaningful, and we were able to iron it out with the buyer. But I'm not sure whether AI would have caught that or understood the implication of what it meant in terms of the warranty versus the useful life of the product. So I think those are the sorts of issues I see there. Then we're all familiar with hallucinations. I don't know if this community is following this as much as I do, but every once in a while over the past year, you hear about a lawyer who is submitting a legal brief to a court and is apparently using AI, and they've cited to a case that doesn't exist. And so to the extent you're asking AI for legal advice and they're relying on cases that don't exist, or I've seen actually recently where a client referenced a statute to me, that statute had actually been repealed. AI isn't reliably giving you the most current or reliable legal precedent to rely on. And they also don't, again, I think I was mentioning this earlier, they don't always understand the interplay between different statutes and different regulations that might be applicable. So it's both not having the right cases or the right statutes and then not understanding how they all impact one another. And then I guess my other pitch to you would be that if you're negotiating a subcontract with a prime contractor, they are not using AI, and they're paying legal counsel to draft terms that are often very heavily weighted in their favor. And that's not a knock on prime contractors, but we see that quite a bit. And so I absolutely appreciate that it can be daunting to spend meaningful resources on legal review of these documents. But when you're negotiating against a company who is willing and able to throw legal resources at a problem, you sometimes just have to match fire with fire.
Gotcha. Ashley, I think it's a really compelling set of reasons, right? Why, what are the risks with using generative AI or using ChatGPT? I think all of those are really important. And I didn't even myself think about the issue of attorney-client privilege, right? And how that's a unique relationship from a legal perspective, and then just the issues with hallucinations and the importance of getting things right. So Ashley, let's shift a little bit. And you deal with a wide variety of companies, both from inside the government and now outside the government, and especially for kind of emerging kind of growth companies. What are some of the common mistakes that you see tech companies making in the government contract space?
Sure. So broken it down to about 5. And some are more important than others, particularly depending on your company and your risk profile. But I think one of the big ones is not having a developed intellectual property or data rights strategy from the beginning. Like I was saying, it can be easy to think about, okay, well, this was privately funded and this is developed with mixed funding. But then it becomes how the functionality of one piece that was maybe developed with private funding is going to interact with the piece that you're maybe building on top of that is going to be developed either with mixed funding or only with government funding. And so thinking through that, thinking about how that's going to impact what the government is asking for, whether getting something with GPR, but it's built on a platform that's delivered with limited or restricted rights because it was developed with private funding, is that going to get the government what it needs? And then also thinking as a company, okay, well, what do I need to protect to make sure that I'm maximizing the commerciality of my product or service, and ensuring long-term revenue growth, those sorts of things. So I think just having a really thoughtful, developed IP strategy before you start negotiating with the government is really helpful. I think the big thing is you never want to be thinking about these issues for the first time when you're negotiating a contract. I think you always want to have thought about these things ahead of time so you don't feel as much like you're under the gun.
Yeah. And Ashley, just you had mentioned an acronym GPR, and
Oh,
I think
yes.
maybe talk a little bit more about how when the government funds something that they typically get the rights to, you know, to the resulting products, and maybe if you could talk through that a little bit, I think that'd be helpful to our firms.
Yes. Thank you. And sorry for contributing to the acronym soup. But so GPR is shorthand for government purpose rights. And so generally speaking, when a government is contributing funding to the development of either some sort of technology or technical data, if they're contributing funding to the development, then they are likely going to either get or at least ask for government purpose rights. And what that means is it allows the government, and by the way, when I say government, I do mean government wide, it's not agency specific. It gives the government the right to use, modify, for whatever government purpose they have. But it does stop short of allowing them to make any commercial use of whatever you've developed, but it gives them pretty broad rights. But the idea is that if a government agency is paying for something, paying for the development of something, they're going to want more rights than what they might otherwise be entitled to if it was developed with private funding.
Great. Thanks, Ashley. That was really helpful. And, IP and data rights is so important, especially if you're a software or providing intellectual property, right, to make sure that you maintain those rights and don't shift those over to the government. That's always been an important one. The next one on your list there, Ashley, is a pricing strategy and not having that. Maybe it'd be great if you could kind of share what do you mean by that, and what are kind of best practices that you've seen from a pricing strategy standpoint?
Sure. So there are several government clauses, FAR clauses, that deal with price reduction. And then on the commercial side, it's somewhat similar. It's sometimes referred to most favored nation clauses. But basically, the idea, both in the government context and the commercial context, is whoever you're doing a deal with, they want to know that they're getting access to your best pricing, right? And so what you want to do is you want to develop a pricing strategy ahead of time so that you are ensuring that your company has maximum flexibility in how you sell your product or service to other customers down the road, but also avoiding liability under these clauses. So avoiding a situation where you sell the CIA your software for, let's say, $1,000 a seat. And then later on, you sell it to some other entity for $800 a seat. And the agency comes back and says, hey, wait a minute, why aren't we getting the $800 price tag instead of the $1,000 price tag? And then essentially starting a claim against you for the difference in cost. And so I think the main idea is thinking about, okay, are there ways to caveat or develop a pricing strategy that is multi-layered? And what I mean by that is you have different pricing, you have different volume pricing. So if an agency is buying 500 licenses, they get one price. If they're buying 50 licenses, that's a different price. Or if a company is willing to agree to certain terms, then they'll get a discount. Or if they're not willing to accept those more favorable terms, then they're not going to get as steep of a discount. But basically, caveating your pricing strategy in various ways to give you maximum flexibility and to try to limit the ability for either another government agency or another company to say later, hey, why did that company get a better deal than I did? And it's like, well, because they were buying more, and so we give volume discounts. And I think one thing to think about, particularly, I think for the companies that are on this call, is when you're first trying to get in the door with the government, and I've had this happen recently with a client where you're inclined to offer discounts because it's really important that you get in the door, you get that first contract. And that's great. And I totally support that. But I think the main thing is to be very clear about what sort of discount you're giving so that there's not an argument later that that should be your standard pricing in perpetuity. That no, this is our standard pricing. We value the government's business. We're willing to give you this discount on this particular contract, but that doesn't represent our general pricing going forward.
Yeah, it's very, very important. And, from my experience, Ashley, right, you also clearly establish your commercial kind of list prices,
Yep.
then establish your government prices. And then when you're offering discounts, really highlight why that discount is being provided, right? And I know sometimes, maybe giving discounts then to commercial customers, you want to do things like, hey, they agree to be a reference, or they agree to a profile, or something unique that justifies why you don't have to share that price. So I think it's a very nuanced item, right, with pricing. But as companies grow and scale, it becomes really important to maintain your margins and also doing things properly from a compliance standpoint.
Right.
So
And you just
yeah.
don't want to get locked in with those first initial prices that you offered when you were you were a nascent company, and so you want to the idea here is just to maximize your flexibility going forward as your point as you grow.
Right. Terrific. Thanks. So, Ashley, let's talk about some of the nuances of government contracting, and what are some of the key things that portfolio firms should be aware of and kind of be prepared for.
Yeah, so I think one of the things here we just try to emphasize a lot with companies is commercial contracting is very different from government contracting. So if you're not experienced with government contracting, there are just some things you want to be aware of. So understanding that only the contracting officer can direct changes or modify the contract. A lot of times, particularly at the CIA, the contracting officer, technical representative, or COTAR is usually the one engaging most with a company on a day-to-day basis. And I've seen it where sometimes the COTAR oversteps a little bit, and maybe the company doesn't catch it or call them out. And the COTAR is essentially directing a change in the scope of work, and it's never memorialized by the contracting officer, and that can just create some problems for companies. So just being mindful that that's really the only person that has the authority to change your contract. Another thing is that the government has unique termination rights. They can always terminate for their convenience in addition to their ability to terminate for default. They have the unilateral right to exercise option years. So that's just also something to keep in mind when you're putting together your proposal. If it's contemplated that there's going to be a base year, but also multiple option years, making sure that you account for the different considerations in those subsequent option years, because the government can just unilaterally exercise those without needing your consent. But then another thing I think, particularly for technology companies, is understanding how the government uses contractors on potentially your contract, and ensuring that there are non-disclosure agreements or some sort of other agreement with similar obligations in place, so that you're not giving sometimes competing companies access to your protected and confidential information.
Yeah, that's definitely very, very, very important. So from a contract obligation standpoint, maybe I think that's, hopefully, right, no one ever gets to the point where they're not delivering what they stepped up to in a contract. But I think, Ashley, maybe it'd be great if you could kind of share, the recourse and kind of some of the things that the government can hold companies to.
Yeah, I think some of the issues we sometimes see are not fully understanding, like, let's say you have to deliver a widget. A lot of times the government will also have different periodic reporting obligations that are also deliverables, and those can require quite a bit of time and resource expenditure on behalf of a company. So I think being mindful of reviewing for those when you're negotiating the contract and making sure that they're not overly burdensome and truly understanding the amount of resources that are going to be required for those sorts of things. But I think there's also, look, we all do it. We all get terms and contracts and we sign them without really thinking about it. I did it the other day with a pod delivery. I totally get it. And especially in government contracting when there are so many clauses and so many terms. But there can be some things, for example, like audit rights and data and document retention policies. And it's really important to ensure that your company's internal policies and procedures align with whatever is in your contract. And so I think that's what I'm both understanding what your deliverables are, but also understanding what your compliance obligations are and trying to make sure that whatever internal policies and procedures you have in your company are mirroring those terms. And if they're not, then go back to the government and say, look, our internal data retention policies are 3 years, not 5 years. So we need to modify that term. But things like that.
Okay, great. That's very helpful. And Ashley, from a compliance standpoint, right, I think it's important too that our portfolio firms are aware of some of the restrictions, right, around buying meals for government or entertainment or gifts, as well as restrictions about hiring people from the government. So it'd be great to get your perspective on that, and if you see that as a common issue with firms entering the government market.
Yes, so absolutely. And I think as companies are building their teams out, there's definitely a thought of, oh my gosh, wouldn't it be so great if I got to hire this person from this particular program? We're targeting that program, we're targeting that division of whatever government agency, having someone who's been on the inside to come help our company grow. And I understand that, but there are restrictions. There can be cooling off periods depending on what they've been working on, what level of seniority those employees have. So what we often advise clients is, and we've developed these, I guess I haven't included on the slides here, but we do have sort of screening checklists for companies that include questions so that you can ask an applicant up front, what programs have you worked on? How long have you worked on them? What sort of information does it give you access to? Those sorts of things, just so that companies can make an informed decision and understand, okay, if we hire this person, maybe we'll have to firewall them off of a particular opportunity we're bidding for a year or so. But the main thing here is to understand what those restrictions are, because the last thing we want for our clients to do is hire someone and then because of whatever that person worked on while they were with the government, the company now can't bid for potential work with that particular program or that particular division. And we've seen that happen. So that's what we're really trying to avoid there, is making sure that a company is keeping their business opportunities open, or to the extent they're willing to say, okay, we understand we won't be able to bid on this particular contract coming down the pike, but we think hiring this person is worth it. That's totally fine. But making sure that a company is making that decision from an informed place.
Excellent. Okay, that's great, Ashley. I think you've really highlighted some important issues and topics for our portfolio firms to be aware of as they start down the path of building and scaling their government business. So from here, let's shift a little bit. I think it'd be great, right? Sometimes I hear from portfolio firms, "Oh, I don't have the funding for legal. It's going to cost a fortune." How do firms approach this from what you've seen? And Ashley, I think there's probably ways, right, from using templates or standard processes where maybe there's ways to maximize firms' investments in legal spend. Be great to get your perspective on that.
Absolutely. And so that's actually one of the reasons I joined my firm, is when I was meeting with firms, I was explaining the types of clients that I wanted to help. And I knew that cost sensitivity was going to be a meaningful decision point, I guess, for companies. And so I chose my firm because they understood that they're willing to be very flexible with me and my rates. And they've also helped me in developing something where we've developed a couple of templates and checklists for companies. And I actually have to give kudos to a portfolio company that was the one who gave me this idea. I met them at the CEO Summit earlier this year, and they were talking about how to use AI and also complaining about legal spend, and I totally get it. So what we've come up with at our firm, just as an initial I guess, prototype, to use a word that you're all familiar with, is a couple of different templates and checklists. And the idea here is we've tried to take some of the more frequent issues and come up with advice that companies can use, and they can use both by themselves and then with a couple hours of our legal services on top of that. They're offered for a fixed price. So I know predictability of legal spend is really important. So understanding this is what you're getting, it's only going to cost this much, and then you're done. So a couple of things. We've developed terms and conditions for government customers. So I think a lot of companies will already have commercial terms and conditions ready to go. But what I saw on the government side is that there are a lot of standard commercial terms that government agencies simply can't agree to, whether it's because they violate the Anti-Deficiency Act or some other regulation or statute. So what we've done is highlighted the most frequent commercial terms that we see that cause headaches for the government and suggested replacement terms that can be accepted by the government, but are still very protective of the client. And with that, we've included a couple of hours of legal reviews. So the idea is a company can buy that template, it can take its commercial terms, and it can swap out the terms that we've drafted for you, and then it can give that product to us. We can just spend an hour or two looking it over, making sure there's not another term that maybe we didn't anticipate that still needs to be addressed because it's going to be a problem for a government customer. And then you're ready to go. And you've got your terms specifically for government customers, and you don't have to get into some protracted back and forth negotiation. I think this is really important for companies that are working with agencies that utilize OTA authority, where the government is going to be more willing to adopt a company's terms. Then you have these, they're ready to go. You don't have to do a lot of back and forth because the government's saying we can't accept automatic renewal provisions. That's a violation of the Anti-Deficiency Act. So that's one. Another one is non-disclosure agreements. So under what we've developed are our tips for the various provisions that companies need to look for. Again, the idea is a company takes that, they review the non-disclosure agreement, they highlight whatever issues they think are going to be a problem based on what we've flagged, and then they provide the document to us, and we can do a much more streamlined review, understanding that the company has done sort of like the initial first review based on the guidance that we've provided. And then similar with subcontract, we've taken what we generally flag as the most problematic provisions in a subcontract between a sub and prime, and explained what the issues typically are and given some guidance about how to modify those terms. And again, the idea is the company can take that, they can look at a subcontract, they can review it based on the guidance we've given, make whatever modifications they think are appropriate, give it back to us. We can spend an hour or two doing a scrub to make sure we haven't missed anything and that all the changes are appropriate. And then again, you're protected. It's, again, a firm fixed price, and it's hopefully a lot more cost effective and efficient for companies.
That's great, and that's important. And actually, you know, from my experience, right, like before you get to a point of a subcontract, right, usually a lot of times you'll work with a system integrator or prime contractor on a program or on a bid, right? And what's your perspective about the importance of having a teaming agreement and you know, just kind of that whole process of providing pricing, providing information to a prime about your products and capabilities and the risks of doing that without a teaming agreement. What's your experience there and kind of recommendations?
Yeah, I I think it's like most things. You go into most things with relationships. You go in with the best of intentions and you hope that it's going to be a great partnership and everything's going to work out, but you have the teaming agreement that lays out the various roles and responsibilities and protections just in case things don't work out. Um, but but I think it's also really helpful because even if it I should say it's not just if it doesn't work out. It's also if it does work out, because if you get the contract with um, the government agency that you're bidding for, but you want to be clear up front about what each company's roles and responsibilities are going to be if you are ultimately successful in getting that contract with the government. Um, and I think a lot of that is just about planning for companies to understand um, what they should be prepared for, um, any pitfalls that they might need to be building, or issues that they might need to address internally in the company before they get to the award phase. Also understanding whether their agreement with the prime contractor is going to be exclusive or not, whether we see this sometimes in teaming agreements, sometimes in non-disclosure agreements. It can crop up in a couple of different places, but understanding whether the prime is putting any restrictions on the subcontractor in terms of other business opportunities it's able to explore. Is the teaming agreement exclusive, or can the subcontractor move forward with proposals with other prime contractors, those sorts of things. Because I think, especially as you're growing your business, you want to be mindful about not cutting off opportunities where you can, um, but understanding the practical realities of um, if you're building or if you're bidding on a contract with a prime contractor, those are sometimes the things that they might be looking for, but understanding how much room to negotiate you have there.
Great. Thanks, Ashley. So, Ashley, we've kind of talked about three kind of uber topics so far, right? The first was why generative AI is not a proper substitute, right, for effective legal advice, which I think is really important for people to understand. And we talked about kind of some of the common issues or pitfalls for companies that are entering government. And you've just shared a great list of kind of the power of using templates and then using these templates as a way to maximize legal spend for portfolio firms, right? So I think all of these topics are hopefully very, very helpful to our portfolio firms. I think it would also be great here as to talk a little bit about your experience, right? So you've had a really very interesting career, starting working at NOAA, Department of Commerce, working in private industry, and then being, an attorney at CIA. And as you've now kind of shifted from that experience and are kind of advising and working with startup firms, like what are some of like the key things that you've taken from your government experience that you kind of kind of been bring best practices to advising firms that are entering the government market and are in an early stage from their growth perspective?
Yeah, I think the most important thing is to just try to always make decisions from an informed place. So the more thought you can give to issues ahead of time, the better, and understanding what your risk profile is. And that can really be personal. It can also depend on what sorts of goods or services your company is providing. Um, and that's more general, but I think particularly when you're thinking about trying to do business with the agency or other um, intelligence community agencies, um, I think some of the things to keep in mind are that um, the people you're working with there very much believe in mission, and that is what is driving them. Um, but they aren't, and this isn't out of a place of maliciousness or anything like that, but their first priority is not necessarily ensuring that your company is successful.
Right.
So just making sure that you are advocating for yourself, and this sounds sort of silly and perhaps some generation Gen Z something, but like knowing your worth.
Hmm.
So, when you think about engaging with a prime contractor, it's to your point, Barry, a lot of these companies get their start in government contracting by working with a prime first. And it can be intimidating negotiating with a prime contractor that's been in this space for decades, and has a well-developed relationship with whatever respective agency you're ultimately going to be working for. But the prime contractor is working with you because they need something from you. And so you need to know that and to internalize that and to be willing to push back when you need to push back. Now, you don't want to push back just for the sake of it, but if there's something really important, like particularly intellectual property rights, that's something worth going to the mattresses for. And in my experience, prime contractors know that, and their opening salvo might be to try to get as much as they can, but once they understand that they're working with a company that's willing to push back a little bit, they're not going to draw a line in the sand. So I think that's really important to keep in mind. But similarly, government agencies are going to be looking for what they need, and they aren't always as thoughtful about, okay, well, if I ask for this level of IP or data rights now, that's going to impact the company's viability going forward. So maybe I should be a little bit less stringent on the front end. So you really need to be your best advocate. And then just understanding the intricacies of some of these agencies. And when you're thinking about compliance, I don't think anyone necessarily expects 100% compliance with your contractual obligations, but understanding what the government is going to care about and what the government is going to be a little bit more lenient about, so you can understand how to prioritize your resources. And then especially at the agency, I think there's to be wary of that. They can often treat contractors a little bit like staff. And so that can just sometimes blur the lines of what's appropriate for a contractor to do and whether you're deviating from the scope of work. And so I think just understanding that and understanding how to best navigate that to ensure, again, you're doing what's best for the company.
Great. That's very good advice. And Ashley, from your experience, like if there's kind of one lesson that you'd like to share with our audience today, that every startup should be aware of, like, is there kind of like one key nugget that you'd like to share with them today?
I think, if I may, two things.
Sure, that's okay.
So one, I think as you're starting to build out your government contract business, I think building your internal and external team, to understand who's going to be responsible for reviewing the contract, who in finance needs to be involved, who in HR needs to be involved, and just sort of having a good understanding of who within your company, or if you have outside legal counsel or outside consultants that are helping you. But again, just having a good team in place so that when you're drafting a proposal or you're working on a contract or negotiating a contract, you already have the team in place that's going to be best positioned to address whatever issues come up and do it most effectively and most efficiently. And again, like I was saying, the more you can think about some of these issues ahead of time and not be working through them during contract negotiations, the better off you'll be. And then the other thing is just to read the contract. I realize that sounds really silly and basic, but I think more often than not, we see issues with clients because there just wasn't a particular provision of the contract that they really zeroed in on that ended up being an issue. And so I get like, look, if you're the CEO, you don't have time to review every government contract. That's totally fine. But that's again where I think that having that team in place is really important to make sure that someone in the company is responsible for reviewing the contract, understanding what your obligations are going to be, um, and making informed decisions about how the company is going to address those obligations.
Great. Thanks, Ashley. I think that's really great advice, right? I mean, I think people are always very anxious to kind of get a contract or a deal closed and get it signed and in place. But I think having that thorough review done and really understanding the implications and obligations are really, really important, right? And that celebration of winning the contract kind of comes and goes, and then you focused on delivering, and you really want to make sure that you understand what you're getting into. So thanks. So Ashley, we'd like to shift now to a Q&A in the last couple minutes of our event today. So I'd like to remind the attendees, if you have a question you'd like to ask Ashley, you can use the chat feature and just put that question in there. We've got one coming in here. Let's take a look at that. And the question, Ashley, is you touched on hiring an employer from an employee from government. How open is the government for agreeing to terms on poaching? And I guess that means the government hiring their employees, I would assume, but maybe you can give us your perspective on that.
That is interesting. I will have to admit, I'm not sure that I've ever dealt with that issue. I think I would be interested to hear other people's experience. I'm I'm always of the mind that it doesn't hurt to ask. Um, I would be inclined to think that at least my former employer would not want to agree to that sort of a term because they're always going to be looking for the best and the brightest.
Hmm.
Um, but I also think you could come across some reasonable people who say, look, while you're working, while at least, and there might be certain restrictions around it, but while you're working on an active contract for the agency, we agree um, not to actively poach your employees, but
Okay, great. Yeah, that is a very, very interesting topic. Ashley, here's another question. From your experience, where do you see areas that early stage companies kind of overspend from a legal perspective, and how can they maximize their investment?
yeah, I think a lot of times it's um, it's cleanup. Um, so I think, not to speak in platitudes, but what is the saying? An ounce of prevention is worth a pound of cure.
Right.
I think that's where I've at least seen things is um, a company is trying to clean up something that they've potentially already agreed to or gone down the road rather than bringing in legal counsel earlier in whether it's a dispute or some sort of disagreement, and you generally end up overspending to correct the problem on the back end than if you just tried to address the issue in the front end. Um, and so to that point, we had a client who has a Department of Energy contract, and there are some unique intellectual property statutes and regulations that apply specifically to the Department of Energy. And based on our conversations with the company and their risk profile, particularly with regard to their intellectual property, I probably would have advised them not to bid for the contract in the first place because they just can't quite get comfortable with the level of ownership or rights that the Department of Energy is going to have and whatever is developed under the contract. Um, but now they're in the contract and they're having to work it out. And so we're having to have a lot of engagement with the company. But I think had they come to us in the first place, I think our advice would have been, this is probably not great for you. It would have been a really quick advisory session. as opposed to several protracted months of going back and forth with them and with the government agency to try to work out terms that everyone can agree to.
Yeah, that's certainly important, right? You don't want to waste months of time and effort when it could be addressed up front. So yeah, that's critically important. Um, so Ashley, today's discussion has been great, right? I think you've shared some really terrific lessons learned and suggestions for firms um, uh, who are, entering the government market. We've had a great dialogue. Any kind of closing thoughts before we wrap today? I'm sharing a slide here with your contact info, and I assume you're fine if people reach out to you at this email
Yes.
address, apowers at milchev.com, right? But it'd be great if you have some closing thoughts, Ashley. Thanks.
Yeah, I want to thank you all for what you do. Having worked at the agency, it gave me a front row seat at how important technology is to the changing national security landscape. So I appreciate everything you do. And if there's ever anything that I can do to help your companies, my primary goal, like I said, when I left the agency, was to make sure that I was a good advocate and a good resource for companies that are trying to build their businesses within the intelligence community and DoD space. So if any of the templates or checklists sounds like things that would be helpful to your company, or if there's anything else that I can do, please always consider me a resource. And again, thank you for what you do.
Great. Thanks, Ashley. Really appreciate your time today. Thanks for sharing your experience with our portfolio firms. For our audience, thank you for your time and your attention today. We recorded today's event. Each of you in a couple of days will get a link to a private YouTube channel that you'll have in terms of the recording. And it's fine if you share that recording with others in your firm that you think this would be helpful to. So with that, we look forward to our next event for our Government Platform Accelerator. And you can always reach us at gpa@iqt.org if you have questions or ideas. Thank you, everyone. Goodbye.